Good afternoon, everyone, and welcome to the Law News Network. I'm Misty Maris, and I'll be your host for the next few hours. Right now, we were live earlier today in the Toledo courtroom for the penalty phase of the Toledo case. Now, Toledo was convicted of 3 counts of murder against his wife and her 2 children. What we saw on Friday was Toledo saying, look, I don't even want to present any mitigating factors in the penalty phase of this trial. I just want to be sentenced to death. From what we know, it looks like the defense intends to put on some of those mitigating factors from their opening statement. It appears they're going to go for some sort of mental capacity type argument, perhaps that he had suffered from some sort of injury in the past that could have impacted his actions moving forward. We anticipate being back in that courtroom in about an hour from now at 1:30 to continue with testimony in the prosecution's case in that penalty phase. But while we wait for court to reconvene in the Toledo case, we have some information about Adam Matos. This is the Florida quadruple murder case. Right now, the case in jury selection, but we anticipate opening statements tomorrow where the prosecution and the defense will lay out their case. Interestingly enough, at LawNewz, we've acquired 739 documents that our own Aaron Keller has been painstakingly going through to give us a preview of what we can anticipate seeing in the courtroom. I'm here with Aaron Keller now, another LawNewz host, my esteemed colleague. How are you today, Aaron? Thank you so much.
I'm good. It's always nice to see you here, Misty. And look, it's painstaking to go through these documents because I really need 2 screens.
Yes.
Trying to go through this length of documents, look, I mean, not all of them are relevant to the kinds of discussions we have here, but they do give us a sense as to what's going on with the evidence in the case. And oftentimes we're sitting here watching the trial, and you and I and others have questions that say, you know, is there something else that's just not making it in? Do the rules of evidence prevent something else from coming in? Is there something else that the attorneys tried to investigate, but it led nowhere? Well, a lot of these documents answer those questions, and in this case, we have been able to get our hands on them. So we have a lot of questions that oftentimes aren't answered in this case.
Which is why it's excellent that you have that, and it also gives you a sense of what the attorneys are going through when you're talking about trial prep in general. That's the amount of documents, if not more, that the attorneys are living and breathing every day as they prepare to move forward with the trial. You brought up a great point, Aaron. Now that we know what's in that court record, in the documents that we have, we'll be able to talk about what the jury is not going to see as the trial progresses and maybe discuss why or why not. Something might have come into evidence, but in general, what are the types of documents you're looking at here? Are these deposition transcripts?
It's deposition transcripts, it's documents filed by the police, it's this whole mix of information. So, you know, one interesting thing that's come out of it is there has been a lot of jockeying as to whether or not a child in the record, the only thing we have is the initials, and the initials are TB, so that's what everybody is calling this child. But it's the son of the defendant and the victim. Okay, because in the record that we know right now, and we don't have all of it, we have a good chunk of it, but this child refers to the defendant as daddy and to the one of the victims, Megan Brown, as mommy. And the child has autism, and from what I understand from the record, it's relatively severe. So the child is not able to communicate very well verbally. The state's experts confirmed that. But ultimately, here's the thing. The child has done and said a few things in the purview of investigators that really suggest maybe the child was either present for domestic abuse or for the murder. But here's the thing. It's not clear whether or not the child is competent to testify. And there was a lot of back and forth wrangling. This child was deposed 2 separate times. Once was a couple of years ago, and the other was just a couple of days ago. So they were still pushing at this up until the end of last week, trying to figure out whether or not this child would be able to testify. And ultimately how it appears to have ended is the state just turned around and backed away from it and said, we're not going to try at this point.
Well, that's interesting.
It's an issue that potentially could flip the case on appeal. So why would the state go there, okay, to put this evidence, which is extremely damaging, But why go there if the state thinks it's going to win its case the other way? Because then if it gets flipped, where are we? We're back at another trial.
And certainly that would be what the prosecution is thinking. We want to get these facts into evidence, and what's the best and cleanest route to get some of those damaging facts of the defendant into evidence? And maybe it's not through the child. What I do think is interesting, when you're talking about a child testifying, the standard is, does the child know the difference between the truth and a lie? And in any sort of testimony, whether it be deposition, at trial, there's a competency hearing for that child to even sit for that deposition to see if they're able to testify under oath. Now, from what you've read in the record, was the competency issue related to the child's diagnosis of having some sort of having autism, or is it something else?
That seems to be what it is. So, look, in one of the interviews, there were attempts at depositions. In one of them, the child responded to almost every question by simply repeating his name. So that's one of the critical facts that I think people looked at and said, all right, well, can we believe everything? But see, let's get into some of the other things that were said. At one point, the child picked a doll up and started pounding the doll as if the doll were a hammer on, I think it was a table, and saying, "Mommy, mommy, mommy." Well, that's one thing. Okay, well, does that sound really damaging, or is it just an outrage? Parents may differ on that. It goes further, though. There's one other deposition of someone from Child Protective Services who testified in the deposition that at one point the boy picked a doll up, and then it's a little unclear exactly how it was done, but said wrapped it up in the window blinds, I'm assuming with the cord, and let it hang there. And it was done in a response to questions about what happened to mommy and what happened to daddy in the immediate aftermath of when the murder was discovered. And then at another point, they said, well, where's mommy? And he takes the doll and lays it down and puts a blanket over it. So that's another little interesting piece of information here, and it goes a little bit further. At one point in one of the depositions, the child apparently said, "Daddy killed mommy." Okay,
right.
Well, I think that what the defense was getting at here, so if you're the prosecutor, that's the gold that you're looking for.
That is very clear.
Okay. But see, here's the thing. At that point, had this been talked about among other people? Was the child exposed to news reports by that point? We don't know all of what was said that may have been feeding into that. And is it just a situation where the child was just repeating back an accusation? So at face value, all of this stuff can add up to look really, really damaging, but I think the state made the right call in just backing away and saying, we're not going to go there, because the state has some pretty good evidence, even without trying to figure out whether or not this child passes a competency test. Look, the defendant, they believe that these murders happened on a date, October 28th. The defendant called one of the victims, the ex-girlfriend, Megan Brown, 200 times between 6:11 a.m. and 8 a.m. on the 28th of October. Okay, 200 times? That's
right.
A little
that's
bit
excessive, let's say.
That's not just obsessive, that's
right.
Excessively obsessive. We should come up with some words for this. Ultimately makes his last call to that particular victim 4:12 p.m. Defendant never tries to call her ever again. Okay, at that point. The defendant spotted by neighbors at the murder scene at 12:35 in the morning the next day on the 29th. So there's this supposition that at some point in there between 4:12 p.m. and 12:35 a.m. that he's in the scene. You've got these calls. You've got a domestic violence accusation within the preceding couple of days. Then you've got the defendant posting some of the victim's items on Craigslist on the 29th for sale. He's trying to sell their TV. He sells that on the 29th, and they've got the person who bought the TV. Okay, I bought it from this guy. They have the Craigslisters who bought some of the Brown family's dogs, because they had some purebred dogs, as I understand it, on the 29th, the day after. Then you've got the pizza being delivered to the murder scene the day after using one of the victim's cards. The mother, Margaret Brown, she doesn't show up for work. People stop showing up for work on the 29th. Then the defendant goes in the family's van to Walmart at 11:30 at night on the 29th and buys a shovel, and they think it's the shovel that they later found in the van with all the blood and the body fluids and everything else. So they've got this relatively nailed down, it seems, against the defendant. Maybe as to the child, the state just doesn't want to go there and push an issue that could be the issue that flips it on appeal.
Definitely, especially if you have other evidence that could get you that conviction anyway. Plus, with respect to the child, while you do have that one statement, daddy killed mommy, as you said, that you found in the deposition transcripts, the defense has that argument. Well, perhaps he heard that down the line as time went on, more information came out about the story. Also, if that child were to testify and you're talking about what happened in the underlying deposition transcripts with reference to the doll and this is what happened and mommy was this way or that way, you need a medical expert to then come on and talk about how dolls are often used for children in order to describe situations, circumstances with psychological experts. There's a lot more to it than just a cut and dry, this is basically a statement of a witness who saw this crime being committed.
Yeah, exactly. And look, I mean, the child's mother's cause of death was a gunshot wound. It wasn't any kind of hanging or strangulation or anything like that. So, you know, there's an accusation that the defendant had threatened this particular victim with a knife. There's really nothing in the record to suggest that that kind of thing even happened. So, you know,
it's not as lock solid as it may
that's
sound.
That's exactly it. It's not lock solid. And I think that there's other evidence here that's going to make the case for the state without going into this muddy water with what the child saw, observed, and whether or not the child is able to adequately explain what happened. I don't even have, at least I haven't found it yet in the record, the child's age. It seems like it's a very young child. You know, just a horrible situation because the child is ultimately had to be taken by distant relatives in New Jersey. Right. But, you know, look, is this an accurate picture of what happened? The evidence doesn't per se back all of it up. And I think that the state made the right call by not forcing the judge to make the call, because then you can just picture this thing turning into a train wreck on appeal.
Absolutely. And you also run the risk that even if you didn't have an appellate issue, possibly, provided that the kid gets on the stand and testifies, what if the child doesn't have a consistent story or it actually has a negative impact on the prosecution's case? It's actually very difficult to put a child on the stand and then impeach them with their prior testimony. It can be very off-putting to a jury, especially when you have a child who's clearly gone through some trauma of his own.
Exactly. And, you know, look, I go back to believing that this was the right call, and kudos to the prosecutor for not going at this thing full throttle, because as a prosecutor, you have to weigh your case and you have to weigh your evidence. And if you think you can get a conviction without a piece of evidence that's going to be legally questionable, look, don't go there.
Right.
Because we see these other cases here on LawNewz where prosecutors are trying to throw everything in, and then what do we wind up with? We wind up with hung juries, we wind up with second trials.
You actually lose credibility sometimes for doing that. Absolutely.
That
with the jury, you lose your credibility when you throw everything at the wall and wait to see what sticks.
And
make strategic choices about what you're going to put up there on the stand.
Not only that, but it gets into the whole question of overselling a case. A prosecutor can't oversell a case, because if you try to make something look way worse than it really is, the jury's not going to buy the prosecutor's credibility.
Definitely. And that's all goes into the trial strategy of the prosecutors and ultimately the defense attorneys as well, which brings me to my next question. In your review of all of this material, these deposition transcripts, what do you see the defense hanging on to? Where do you think the defense is going?
Well, if I were to guess, I would seem to think, based on what's in the record, that the defense is going to point the finger at an alternate suspect. And this is where things get really, really interesting, because there's a woman who apparently knew these victims, or some of the victims, in Florida, who ultimately married somebody in Wichita, Kansas. So she goes and moves up there, and she's way far away from Florida at this point. But she stays in touch with all these people in Florida, and there's this bizarre, I don't know what to call it. I don't know if it was a love triangle. I don't know if it was a stalking situation, because there's an accusation that this woman in Wichita was stalking a couple of the people in Florida who ultimately became victims. That's Megan Brown and Nick Leonard, okay? There's complaints being made, there's accusations that and there's some evidence to suggest that somebody in Kansas is hacking into the victim's account, Nick Leonard's accounts. And he's got IP addresses from Kansas, and he said, the only person I know in Kansas is this other person. I think that this other person in Kansas used to date one of the victims. And the other bizarre little element of this is the person in Kansas, worked for one of the wireless providers. And there was an accusation levied against a wireless provider that she may have been using internal computers and processes to hack into and figure out what some of these victims were up to. Now, this person was at work in Kansas on the 28th, 29th, and in the times surrounding this particular murder. And there's this one little line buried in one of the depositions that there's some insinuation, well, gee, could she have hired a hitman? The defense was trying to ferret that out. And I haven't been able to figure out whether they got so far as to figure out that it happened or didn't. But it would seem that it didn't, because then the police were very clear in saying, look, we looked at this particular person, we sent an investigator from Florida all the way to Kansas to interview this woman who worked for the cell phone company up in Kansas. And the woman lawyered up, and ultimately we didn't get anywhere. They did take phones from Kansas and ran the diagnostics and pulled all the messages and looked, presumably it was this woman and somebody else's history up there. Trying to figure out whether there was someone else. Police say no. Defense is really trying to figure out what may have been going on there, because some of the circumstances are just very, very bizarre.
Yeah, it sounds a lot more, this case is a little more complicated than it
Yes.
looks on its face. So when I first read about the case and what we knew the prosecution had in their hand, and that was the information we had out there in the media before you dove real deep into all of the actual records from the investigation, it really looked like a pretty lock-solid case for the prosecution. But now we hear about an alternative theory that the defense may provide to the jury just to raise reasonable doubt. Aaron, do you see this being the type of case where the defense is going to go after the investigation? We've seen that in so many of our cases on LawNewz. The defense says your investigation wasn't adequate, you didn't fully investigate this particular person who could have been the perpetrator. That could be another path that they take.
They could take that path, but based on what I know right now, I think it's going to be really hard to make that connection, because I think the police, look, the bottom line is the defense knows about this alternate suspect because the police investigated her. Okay, I think that what the defense is going to try to say, though, is that maybe there's a way that this alternate person was involved that we just can't find in the record. Keep in mind, the person had access to internal cell phone company computers and wound up resigning her job in lieu of being fired because she misused the cell phone company's computers to look into family members' accounts, which is prohibited. See, you've got a lot of stuff going on with this alternate suspect. Is it a whole lot of nothing? If I were to guess at this point, again, and this is a huge guess, maybe there's something I haven't gotten into yet, it sounds almost like it might be. So in other words, this defendant may have committed this crime, but there may have been this weird other thing going on the side, independent from what else was happening. But look, I mean, this person in Kansas, it was even accused at one point of trying to call one of the victims at work and disguise her voice and claim to be someone else. The whole thing has just got these really bizarre twists in it. And it's not just one twist or two twists, it's like 20 twists.
Yeah, it's convoluted. It sounds like a movie almost, but
it does.
It really does. When you're talking about what the defense would do with that information, though, might be a whole lot of nothing. But even still, the defense can present an alternative theory. They don't necessarily have to prove that theory. All they need to do is raise that reasonable doubt.
Well, yeah,
so you have this weird situation. If the defense is able to get some of that in, get that before the jury, could that impact the jury's determination at the end of the day? Perhaps.
You know, it could, and I'm sure that that's what the tactic's going to be. And look, I think that you can have an alternate theory, but it helps to have facts to back it up. And in this case, there's not just one fact. You've got this person, you've got complaints, you've got victim Nick Leonard's mother telling everybody that she knew that this was a problem, that this person in Kansas was continuing to inject herself back in Nick Leonard's life. And it's like, this person in Kansas married somebody else, keeps going back at Leonard, who apparently was an ex-boyfriend. It's like you've got the ex-boyfriend getting allegedly stalked by somebody in Kansas, then that same guy is dating this new girl, and they both become victims together along with her parents from the girl's ex-boyfriend, and it's like it's just a massive tangle of what do you call it? What did Shakespeare say, or who was it that said, "Oh, what a tangled web we weave"?
Yes.
Yeah. So it sounds like that kind of thing, and I think that the defense had at least enough here to make an arguable point. They can articulate this. They can name someone. They can point to documents. They've got depositions. They can subpoena people. They can get people up there and say, hey, look, we've had complaints of stalking. We've got communication. We've got all this other stuff going on. This person in Kansas had taken a trip to Florida not long before the murders. There's enough there to make at least a claim.
Right, there's some substance to put forth in the defense of their client. And
Yeah.
that could certainly be valuable when you're talking about combating some of those other facts that we know the prosecution is going to bring out. Now, to piggyback on that, we know from what we've seen so far, Megan Brown did make some complaints about a fear that she was going to be injured by the defendant during days prior to her death. What do we know about that? What do we know about their history together?
I'm still in the process of getting into all of that, and my notes on it are actually over on the other
Well,
side of
Aaron.
the room. So, but look, I've been on this for how long here? Because I was
Right.
on it in the Toledo case as well. You've got reports of domestic violence. You've got that in the Toledo case. We're watching the penalty phase right now. Well, it's coming up in the next case too, and it's in the same state. It's not a mandatory arrest state.
And that's
I'll
what I
just
find
keep-
interesting because
Yeah.
it's a little different in New York. For instance, the situation you had in Toledo when he came into his wife's place of work and started an altercation with her lover and people called the police. In New York, it's mandatory arrest. That person would be arrested. They'd have time to cool down. Cool down at the precinct, and then they might be released depending on the facts and circumstances of that particular instance. Do we have something similar here?
Well, I was hoping we would, because if we did, we may have two people's or multiple people's lives. You got a quadruple murder and a triple murder, okay, that happened within a day or days of a domestic violence complaint. And in Florida, no mandatory arrest law. So, we have what we have, and the law is starting to bother me. But look, there's a lot of arguments against mandatory arrest laws.
A lot of people think it's gone too far in the states that have it.
Yes, exactly.
So
and some states
there's
have
policy arguments on both sides,
and
understandable.
there's different levels of it, and those who have been watching LawNewz for the last week have listened to me complain about it to the point where their ears are probably bleeding. But I think these are discussions legislatures need to have, because in some states, yes, the mandatory arrest laws are very, very strict. There's a call, there's automatically got to be an arrest, even if it was, somebody just picking up the rolling pin and saying, one of these days.
Right. Why I oughta.
And then,
one of those.
And,
yes.
and then they laugh about it and everything goes back to normal. But then somebody brings it up, a couple of days later. Well, there's automatically got to be an arrest, and
Right. Well,
some people say that goes too far, and,
Right.
and to those who do, I don't really know if I could argue against them. But then you have these other cases where, look, in this case, you've got an accusation by the victim, the girlfriend, okay, Megan Brown, says the defendant had threatened to kill her with a knife, held a knife to her throat, and it was right before the murder. Okay, and so it's just like,
Right.
all right, what's up with that? And then
how many times was law enforcement called that we know of right now in that period of time shortly before the murder? I know one of the allegations was that she said to, was it her boss or a coworker, that she feared for her life, but what was actually done from a law enforcement perspective in response to these complaints, or do we not know?
I haven't dug that far into it yet because I'm sort of going into things at an angle. You got this big, huge file with, what did I say, 700 and some odd pages, or just that's 700 and some odd documents.
We got to invest in more screens for you, Aaron.
Well,
I agree.
if you want to dig into them, Misty, there's nothing stopping you from taking a pile of these things home and staying up until midnight reading them. We know there's at least one, and I don't know what the result of it was, but look, law enforcement seems to have been involved in this thing in a couple of weird different ways at different times. And I'm in the process of trying to review my notes on it all, because you've got this stalking complaint against a person in Kansas, and then you've got the domestic violence. Okay, so that's victim Nick Leonard complaining about somebody in Kansas. Then you've got the other victim, you've got Megan Brown complaining about the defendant. Okay, Leonard and Brown ultimately become victims of the crime. And then there's this other call, and I started reading about this morning, and I'm trying to figure out exactly what went on with this. Megan Brown, okay, the younger of the female victims, it was her new boyfriend and her parents that were killed. Megan Brown made a complaint to the police about threats from a female as well.
Wow.
Now, what's up with that? I think the defense wants to know. It was a defense deposition. What's going on with this? Is this, and I'm sure the defense was at least at that point thinking and may argue, I'm waiting to see, trials coming up, defense may argue that this threat against Megan Brown could at least arguably have been from the woman in Kansas who worked for the phone company who Nick Leonard claims was hacking into his accounts to see who he was talking to.
Yeah, it kind of closes a loop for the defense there if they can make that jump or at least make that argument to the jury.
You got two police officers' names in the record who had communicated with victim Megan Brown about this threat. It was apparently a harassing call. Police didn't take it very seriously and just said, well, here's how you should handle it if it happens in the future. There's some confusion as to whether or not Megan Brown, the victim's call about this female threat, was recorded. And then there are coworkers who claim that people were calling where Megan Brown worked, and it was a woman disguising her voice as Nick. Nick became the other victim. Okay, who's this?
Yeah.
That's why I said this thing is a tangled web. And I think if I were to sit here from what I know right now, I think it looks like the state's got a pretty clear-cut case against this defendant. But there was some other really, really bizarre web being tangled among a group of people here. And I don't know. I mean, ultimately, is it this defendant and this defendant alone? Well, we don't know. That's ultimately for the jury to decide. It looks like at least this defendant was somehow involved because you got blood all over the crime scene, the defendant hanging out there, ordering pizzas to be delivered to the crime scene. It just doesn't look good for this defendant, but there's just so much bizarre stuff going on the side.
There's a lot more to this case than meets the eye, and we'll definitely be seeing all of that unfold in the courtroom. We anticipate in the Adam Matos case in Florida that opening statements will take place tomorrow. Thank you, Aaron Keller, for a preview of what we expect to see in the courtroom as that trial goes on. Right now, we're going to turn